Hello, my name is Sergio Ardila, and I am the top workers' comp attorney here in Morgan, Atlanta. Today I'm going to be explaining some of the basic facts and processes behind a mediation. And this is a workers' comp mediation specifically in Georgia. Some of the principles might apply to different types of mediations, so you might be able to get value even if you don't have a current claim in a workers' comp claim in Georgia. So, before I go any further, I do want to say that in this video, I will not be giving any legal advice. There's no attorney-client relationship that's going to be created. This is just general information that you're able to find online if you do research, but I'm just creating a concise place for you to go ahead and get it all right now. So what's a mediation? A mediation in its basic sense is a meeting, a discussion about your claim, more specifically about the possibility of settling your claim. A mediation is called that because the parties mediate or negotiate with the use of a mediator. And a mediator is a neutral party who will convey messages from one side to the other. Now, traditionally, a mediation was done where all parties would meet in the same location to discuss the claim. Now, because of the COVID and the current status of the world, most mediations are done online via Zoom. So it's most likely that your future mediation will also be done that way. Now, before mediation, typically the claimant's or plaintiff's attorney does an evaluation of the claim and sends to the insurance company what is called a formal demand. And what a formal demand is a formal ask or a formal request for a specific amount of money to resolve the claim. Now, because this is a negotiation, the formal demand is not going to be truly what the attorney expects you to be able to settle your claim for. It's going to be a very high number, an unrealistically high number to start off the negotiation. Typically what the insurance company does for that, or once they receive the initial demand, is they make an evaluation of their own and they tender a first formal offer. Now they can do that before the mediation or they can do that first thing at the mediation. The first offer that the insurance company will tender is going to be a very low offer, the initial offer, and it is just going to be to get things started. Don't feel offended by the initial offer. It is not representative of the value of your claim. It's unrealistic, and every party involved, the mediator and both attorneys and the insurance company, knows that you're not going to accept the first offer. It is just a number to get things going, and it is typically the counterpart of the initial demand. So your initial demand is going to be way up here, unrealistically high, and the initial offer is going to be way down here, unrealistically low. And it is just two numbers to get things going. Now, the process of the mediation itself is a process of negotiation where the claimant and the claimant's attorney are going to move down from their initial demand. The insurance company, with the help of their attorney, they're going to move up, and the claim is going to move down and the insurance company is going to move up until they come to some form of range where all parties could agree that the claim can be resolved for. Now, not all mediations are successful. If you don't settle your claim, there's no consequence with your claim. You will continue your claim as if you hadn't come to the mediation. But if you do resolve it, it's going to have to be in some range in that in between. The attorneys are really the ones that are going to be arguing on your behalf, so you don't have to do any arguing yourself. You're really there just to make a decision when the mediation is concluded. Don't feel offended if you hear some arguments that are maybe misleading from the insurance company's attorney, or some that can possibly be seen as insults. They're not. The insurance company's attorney is just working with a set of facts and trying to protect the interest of their client, and they're doing the best they can to get to that goal. And you will also hear your attorney make some arguments that you might not fully understand. You can always ask, of course, and maybe you can see your attorney exaggerating their position because your attorney's goal is to look out for your best interest and try to get you the highest amount possible. So initially you will hear a lot of arguments back and forth. Later on, you might just be hearing numbers. So first, you might hear that there's a lot of talking back and forth about the strengths and weaknesses of your claim, but then you might just hear numbers. So for example, I might say 100,000, 2,000, you might just hear that until you get to the conclusion. And ultimately, the insurance company is going to get to a number where they will say, we don't have another cent to offer more on this claim. That is going to be their top offer, and that's going to be the goal in the mediation, is to try to get to that number. Your attorney's goal is to try to get the insurance company to offer as much money as possible. The insurance company's attorney's goal is to try to offer a bit below what the insurance company said they were willing to offer. Many times, however, the insurance company's attorney will end up having to put everything on the table. And sometimes, if the number that you were is close to that top number, let's say there's a small gap, the insurance company's attorney might make one last call to the insurance company to see if they will give him or her additional authority to settle the claim, since they are close to coming to a resolution. Ultimately, when they have offered everything that they do have on the claim, it will be your time to make a decision. And you're the only person who can make that decision. Your attorney can make that decision for you. The mediator can make that decision for you. Nobody can. Only you can decide that. And just like that, you can also decide not to settle your claim. Your attorney will give you his or her recommendation, and you can decide if you want to accept that or not. The settlement is completely voluntary for both parties. So the insurance company, nobody can really make the insurance company settle. And the mediator, even though he or she is an attorney, most of the times, he or she is not acting as an attorney that day, so he or she also can't give you any legal advice. They're just there to facilitate the discussion between the parties. The mediation will be concluded either with a resolution or not. And if there is a resolution, then the insurance company's attorney might have settlement documents to provide you that day, or he or she might draft them and send them to your attorney in the next few days. Now, in workers' comp in Georgia, every settlement has to be approved by the court. So after all the documents are signed, everything will have to be submitted to the court, and the court will have to approve everything. Now, this concludes a basic explanation of mediating your workers' comp claim in Georgia. Obviously, if you have more questions, definitely consult with your attorney. If I'm representing you, then just reach out, and hopefully you have a more basic understanding of your mediation before actually going forward with it.